The Joining Forces Alliance wishes to state at the outset that the Children's Code Act number 12 of 2022 does not promote indiscipline, disrespect, or defiance of authority by children. On the contrary, the law expressly recognizes that children have duties and responsibilities, including the duty to respect parents, elders, guardians, teachers, and any other persons in authority, so that they are able to contribute positively to family and community life, to uphold social and national values, having regard to their age and maturity, according to Section 26 of the Act. The recent social media commentary describing the Children's Code Act as a roadmap to anarchy and alleging that it excuses criminal behavior, shields violent children from accountability, or leaves communities unsafe is therefore misleading and legally inaccurate. As organizations working in the intersection of child protection, justice, and public safety, we provide this clarification based on the actual provisions of the law. The Children's Code Act does not lead to lawlessness. The Act does not dismantle parental authority, school discipline, or any justice system. Instead, the Act establishes a structured juvenile justice framework that balances discipline, accountability, and public safety within the development needs of children. Courts in Zambia are vested with clear powers to impose binding corrective measures on children in conflict with the law, including probation, restorative justice, orders, and placement of children in approved reformatory centers, fines payable by parents or guardians, and other lawful orders according to Section 79 and Section 80. Courts are not permitted to simply take no action unless satisfied that the intervention is unnecessary. This is in line with Section 81 of the Act. Anarchy arises where there is no enforceable authority. The Children's Code Act creates firm, specialized authority and not disorder. Why diversion? In children cases, diversion must be considered first and is subject to strict legal conditions according to Section 58 of the Act. It requires acknowledgement of responsibility, suitability, and compliance, according to Section 59. And where a child fails to comply, the matter returns to court and may proceed to trial according to Section 60. Children accused of serious violent crimes in consideration of the circumstances are less likely to be divested and instead are prosecuted before a juvenile or children's court and are subject to controlled judicial outcomes. Bail or recognizance may be granted considering appropriate safeguards in such cases. Section 56 states that the Children's Code Act does not abolish custodial measures. It instead regulates to ensure safety and prevent harm. Children under the age of 16 may not, by the order of the court, be sent to a reformatory center. That's in line with Section 79. Children aged 16 to 18 may be sent to a reformatory center, where no suitable alternatives exist. Courts may order placement in child-approved centers or child reformatory centers with clear limits and safeguards, as well as oversight. The Act prohibits detention of children in adult prisons, according to Section 23, as well as Section 103, due to the well-established link between such detention and increased violence reoffending by children. Where appropriate, facilities are limited. This reflects implementation and resourcing challenges, is not a reflection of the failure by the law. The Act does not require the release of dangerous children, but simply because the infrastructure is weak. Children are not tried as adults, but they are held accountable. The Act, therefore, does not allow children to be tried as adults, in line with the Constitution of Zambia, and in line with international obligations that Zambia has signed to. However, this does not mean that children escape justice. The Children's Court and Juvenile Court have wider powers to impose enforceable, restrictive, and corrective orders that can punish the children in that sense. The law replaces adult punishment with child-specific accountabilities, which evidence shows is more effective at reducing violence, to reoffending children, as well as protecting the society. Confidentiality does not mean that there are no consequences to any crime committed by children. Individual cases involving children are protected from public disclosure by the law, according to Section 25, as well as Section 81. This confidentiality safeguards children from further harm, as well as vigilantism, and does not imply that no action has been taken. The child may be sent to a reformatory center or any approved center, probation, or placement in the care of a fit person or a child care facility. The assertion that the Children Act will create criminals ignores the evidence that exposing children to adult punitive systems increases rather than reduces future violent behavior. The Act explicitly mandates crime prevention, rehabilitation, restorative justice as tools for public safety. This is in line with Section 84 of the Act. In conclusion, therefore, the Children's Code Act No. 12 of 2022 is not a road map to anarchy. It is a firm, balanced, and disciplined legal framework that upholds respect for parents, elders, teachers, and authority, and holds children accountable for wrongdoing. And it recognizes the seriousness of violent crime, protects victims, communities, and reduces long-term violence by breaking cycles of harm. Public concern about crime is very valid. However, dismantling child-specific justice safeguards would expose Zambia to greater harm and not greater safety. The real task, therefore, is strengthening implementation, resourcing, and institutional capacity for misinterpreting the law. I thank you.